Recently, there has been a lot of controversy surrounding Indiana's new Religious Freedom Restoration Act, which was signed into law on March 28, 2015. But what exactly does this law do? Supporters say it is meant to do just what it sounds like: make sure the government doesn't infringe on the religious liberty of citizens. However, gay rights advocates, politicians, and civil liberty organizations believe the law will aid discrimination against gays and lesbians in Indiana, and that it will give businesses, landlords, or employers legal grounds to treat them differently based on a religious opposition to homosexuality. This is a scary thought. The civil liberties of anyone should not be infringed upon due to one's sexual orientation any more than they are based on race or religion. The civil rights movement of 1960 show us that discrimination is unjust and should not be allowed in any instance. Until then, people were segregated by law based on the color of their skin in all parts of life. Kids were not legally allowed to go to certain schools because of their race until May 17, 1954, when the U.S. Supreme Court ruled in Brown v. Board of Education that it was unlawful to segregate public schools by race. But even then, it was a long time before Southern public schools abided by this law. Any form of legal segregation or discrimination is a crime against human rights, and although the Religious Freedom Act may not be as severe as America in 1950s, it has the potential to cause serious problems with discrimination. But to truly realize what this law entails, one must first read and analyze the law. Section 8 of the law states that governmental entity may not substantially burden a person's exercise of religion unless the governmental entity demonstrates that the application of this burden to the person produces furtherance of a compelling governmental interest or is the least restrictive means of furthering such governmental interest. A government entity, in this sense, being defined by the law as the whole or any part of a branch, department, agency, official, or entity acting under the law of state government or political subdivision. Similarly, the term person is defined as 1. An individual, 2. An organization, religious society, church, body of communicants, or group organized and operated primarily for religious purposes, or 3. A partnership, corporation, company, firm, or any other entity that may A. Sue, be sued, and B. Exercise practices that are compelled or limited by a system of religious belief held by an individual or the individuals. These definitions are very important to understanding the law. Section 9 goes on to say that a person who exercise of religion has been substantially burdened or is likely to be substantially burdened by a violation of this chapter may assert the violation or impending violation as a claim or defense in a judicial or administrative proceeding. If the court determines that the person's exercise of religion has been substantially burdened and that the government entity imposing has not demonstrated that the application of this burden to the person produces furtherance of a compelling government interest, then the court or other tribunal shall allow a defense against any party and shall grant appropriate relief against the government entity. So, in looking over the law, what it really did was allow for religious defense in court for someone who claims their rights of practicing their religion have been substantially burdened and would have the backing of the state to intervene and investigate, effectively establishing a legal defense of such. So does this really enable discrimination against homosexuals? The answer is yes and no. Many other states like Illinois do have similar laws, but they also have laws protecting LGBT citizens from discrimination. Indiana has no such laws, and Indiana's religious freedom law is written so broadly that it is left open to discrimination more so than other states. In more liberal cities such as Indianapolis, Bloomington, or Fort Wayne, no court would stand for discrimination, and business owners would likely face protests and risk losing their businesses if they were to discriminate, making the law redundant. But in rural southern Indiana, which is heavily Christian and conservative, a court siding against religious values would be considered heresy, and refusing the service of homosexuals not only becomes a possibility, but a probability. However, on April 2nd, after the massive amounts of social outrage over the implications of the law, a new amended version was created that was meant to quell some of the backlash. The new version of the law eliminated everything after the enacting clause and added in some specifications. It stated that the law could not be used to authorize a provider to refuse to provide services, facilities, use of public accommodations, goods, employment, or housing to any member or members of a general public on the basis of race, color, religion, ancestry, age, national origin, disability, sex, sexual orientation, gender identity, or United States military service. It can also no longer establish a defense to a civil action or criminal prosecution for this refusal. This revisal did its job in silencing much of the social outrage over the law, and rightfully so. The new law leaves no room for discrimination in any form, right? Well, actually, notice how instead of persons and government entities, they are now using the term provider. So, what does that mean? Well, in the next section, the law defines a provider as one or more individuals, partnerships, organizations, corporations, and other organized groups of persons. However, the law specifically states that the term does not include churches or other nonprofit religious organizations, such as affiliated schools that are exempt from federal income taxation, as well as rabbis, priests, preachers, ministers, pastors, and or designees of a church or other nonprofit religious organization when engaged in a religious or affiliated education function. So, although the new version of the law stops companies and private organizations from discrimination, it allows any religious affiliated organization to discriminate with no repercussions whatsoever. Remember, the new version of the law eliminated everything after the enacting clause, meaning the religious organizations are now even freer to discriminate than they were before. For example, a religiously affiliated school can now deny the attendance of students based off sexual orientation. This kind of discrimination parallels back to before the civil rights movement when schools were segregated by race. Back then, people used religion as an excuse to promote the discrimination against African Americans just as they do to promote the discrimination of the LGBT community today. When creating laws like this, we need to be careful not to repeat our previous mistakes. When schools finally were desegregated, even in the northern United States, African American students were met with hatred and violence for just trying to have equal rights as white students. Because when the law promotes discrimination, it creates a mindset that thinks that because it is legal to do things to people, it must be morally acceptable to do so. It is a tragedy that we, in the 21st century, are still dealing with these kinds of issues. We as the human race need to learn how to set aside our prejudices and accept one another for who we are, no matter what race, religion, or sexual orientation.